Try to give the attorney all the information that you can. People are either forced to accept that that's their fate and they're going to be ordered removed, or they're forced to address the order of removal. They'll understand whether or not they should take the risk to try to fix it or just hold the line. Can you still fix your immigration case under the current administration? That's a really popular question that I get all the time. We know immigration enforcement has increased tremendously during the current administration, but does that mean that it's too late to fix your immigration case? I don't think it's ever too late to figure out if you can fix your immigration case. And I think right now there's a lot more anxiety, obviously, than there has been in the past. In fact, there's more anxiety in the immigrant community than we've ever seen, that I've ever seen in 15 years of doing this kind of work and over half of my life working with immigrants in the migrant community. But I think that's more reason why people should at least consult with an attorney to determine what their situation is. They need to be informed, because if you get informed, even if the information that you get is bad information or it's heartbreaking information, at least you're prepared and you can change your behavior, or you can be prepared in case of the worst case scenario, in case you are picked up by the administration or by ICE agents. So it can't hurt. I think the first thing, the first advice, or the first topic in this conversation is speak to an attorney. And when you speak to the attorney, it's very, very important that you give the attorney all the information, any documentations of any applications you've done in the past, any documentations about a court case that you had pending, if you received notice that you missed a court hearing with immigration. Try to give the attorney all the information that you can. Now, there's certain things that we as attorneys can do to try to get that information. But the problem is, or one of the roadblocks that we're dealing with during this administration, is how bad or lacking the Freedom of Information Act requests that we're making. The results are bad in that we're not getting the information we're requesting, or more than ever, the results is they can't find anything, or when we get things, it's so redacted that there's no value to it. So that's kind of like the new world we're living in. So it's very hard to get a clear picture, or it's much harder to do FOIAs. FOIAs aren't as fruitful as they used to be before the administration. So it's very important that if you have documentation or information about your case, that you organize it and you prepare it before you go speak to an attorney. Now, there are cases that we have. Let's talk about worst case scenario, people that are detained. When people are detained and there's a problem in their case that hurts them, like they've got an order of removal because they didn't go to a court hearing. Well, in that case, people are either forced to accept that that's their fate and they're going to be ordered removed, or they're forced to address the order of removal. So in that case, a lot of people are motivated and have to address it by force, right? And in those cases, we can, consult with the family and let them know if there's a legal basis to address the issue, if it's worth addressing the issue. And we're really, and most of my colleagues are, I think, are brutally honest with folks. If it's a case that has really no probability of success, we tell clients that, like, there's no hope. There really isn't. It's not worth it to spend a lot of money on this. And just be prepared for removal. But if we find something in the file, in the person's history, that maybe gives us a little bit of room to try to address the issue, then it's worth addressing. And we have had clients during this administration that were picked up and had orders of removal, and we were able to file motions to reopen. We've gotten those cases reopened and then gotten the individual's bond, and they were released. It's much more difficult to do it now in the current climate. That's a fact. But if we have the right fact pattern and the right history, then it's worth doing, and it could still happen. Now, some things that we're advising a lot of people, and again, everything is really fact specific, so it's kind of hard to talk about this topic without dealing with specific cases. But one of the things that we're seeing is a lot of times the advice that we give people is, yeah, there's a possibility. There are some legal arguments we can make, for example, to reopen your immigration court case. But with, the precedent that we've received in the last year and a half from the Board of Immigration Appeals, appeals, and with what seems to be pressure on the judges to deny things, it might not be a bad idea to wait for things to get better. And people don't want to hear that. But at the same time, people also shouldn't be sold on doing things that could put them at risk or could ruin the only opportunity they have to fix their immigration case. When somebody has an order of removal, generally speaking, now there are exceptions, somebody has one opportunity to reopen that case. So we want to make sure that the client wants to reopen that case, that they understand that there is risk involved. And obviously the other risk involved with that is letting them know that you're here and you have an order of removal, right? The client is apprehensive about that as well. So these are conversations that are best had with an attorney. But, can cases still be reopened? Yes. Tons of caveats to that. And, we can make that determination together. Now, what if your case was previously denied? You had an application with immigration and it was denied. There's a possibility that once the application was denied, it was just denied, that nothing came of it. Okay. And in that case, we can reevaluate why it was denied. Sometimes people's applications are denied not because they're ineligible, but because they didn't respond to, let's say, a request for evidence, or they didn't appeal a clearly erroneous decision from USCIS. In that case, we can look at reapplying for these benefits, and that's an option. Now, unfortunately, one of the things that we have to consider in reapplying is the current administration. So we have to take that into consideration and kind of weigh the risk to see if it's worth it. But yeah, we have clients that in the past have had cases denied. They were never sent to immigration court after their case was denied. They're still eligible for that form of relief. After having a conversation with them, we determine that they're at low risk of being detained and that they have a good shot, and they ultimately do apply for that benefit. Then there's people that have immigration court. They're in removal proceedings. And, when a lot of times when they get to our office, they've already consulted with an attorney, and every attorney's office evaluates things differently. I mean, even though the law is the law, attorneys are their opinions are subjective. They're based on, knowledge, but they're very subjective and they vary. I think that, we get a lot of cases from attorneys who said, you don't have a shot of winning your asylum case, or there's a low probability of winning your asylum case, or there's a low probability of winning your cancellation of removal case, or there's a low probability of your adjustment of status being approved, or there's a low probability of whatever you have before the court. But a low probability means that there's a probability. And I've been doing this for 15 years, and I've had cases approved, granted, where the client was prepared that it was more likely than not that the case was going to get denied. So I think if you have experience and you like litigating cases and removal defense as an attorney, you can offer that to people, and there's a lot of benefits that come from that. One, for a lot of these folks, it's the only application of relief that they can actually fight in immigration court. So fight it. Second, the law of asylum is complicated. What constitutes persecution? What constitutes a particular social group? How do you demonstrate past persecution and the presumption of a well-founded fear of future persecution? These are complex legal issues and legal concepts. And if there's a culpable argument, you make it. And what the administration right now is trying to do is they're trying to convince people that if they don't have the strongest case, that they're committing fraud. That's wrong. It's very clear what a frivolous application is, an application where they make things up, right? We don't take those cases. And if we determine after prepping a client for a long time that we have that, then we tell them, listen, there's a problem here. This is what you need to know before you move forward. But, a lot of colleagues of mine, because we have the right to take whatever cases we want. And a lot of colleagues of mine, don't want to take those cases because they rather take cases that have a higher probability of success. They charge a lot more money for them because they hate losing. But if you have a client who understands the probabilities of success and everything is presented ethically and we litigate the case, there's a possibility that person's case is still going to be pending in 3, 4, 5 years. And that's a win for a lot of people. There's nothing unethical about that. We're We're complying with the scheduling orders. We're keeping the clients informed. We're fighting for the only relief that they're eligible for. And, a lot of people want that. And guess what? Things change. In the future, things change. The person's personal situation changes to where now they're eligible for other forms of relief. The administration is going to change. Things always change. This is my 4th or 5th administration that I've worked, that I've dealt with, and everything is constantly shifting and changing in the immigration world. So, I only say this to let people know that I think if you're in removal proceedings and you want to stay in the US, and you have every right to fight your case. And at our firm, we're more than willing to fight those cases. And it's not easy, because we know that we're filing hundreds and thousands of documents of objective evidence, and we're filing these briefs because we feel like we can win them. And then we lose them, and then we appeal. That's just part of the game. I didn't get into this business for easy cases. I got into this business to advocate for people that I care about tremendously. So, I think that's how it should be done. And, if anybody ever has, we get a lot of referrals from other colleagues. We get a lot of referrals from colleagues who are ALA members, from criminal defense attorneys, personal injury attorneys that send us cases because they know how we litigate cases in immigration court. We know how we prepare applications with USCIS. And that's something that we're very, very proud of here. And I get to work with, I'm going to brag a little bit about my firm now. I get to work with 4 other amazing immigration attorneys that I consider friends and colleagues. And they're all colleagues with really good reputations among the bar. So I think having that, is unique within our group of colleagues, and it creates an environment that is different than most of our colleagues, because we work all the cases together. I think every Friday we meet about the trials that we have coming up. So we're constantly, exchanging information and brainstorming all these different ideas, and it's an absolute blast. So I say this only to say that it doesn't hurt if you're somebody, you have a client, you're an attorney, and you have a client, and they have immigration issues. It doesn't hurt to have them reach out to us. We don't charge the consultation. And at least if there's nothing we can do, the person is informed about their situation, and they'll understand whether or not they should take the risk to try to fix it or just hold the line. And we'll be more than glad to talk to them. If you like this episode, please subscribe to our YouTube page. Follow us on all the social media accounts that we have at our presence. Feel free to send us a message. Feel free to call the office, 678-503-2780. Thanks again for watching our podcast, and I look forward to seeing you at the next episode.